So I've got both of those as well. Did you get a copy of both of those?
By both, do you mean the original? I got his like one paragraph motion that I submitted a response to, but I did not get anything further than that.
Well, you got what I got. I'm just saying if he's filed two motions.
I did
One of
not get the
them,
second motion.
one of them involves a motion to contest a tax refund offset and request for review. And the second one is a motion relative to child support. Did you get that one?
I just got the one that's like a handwritten paragraph. I don't, that kind of talks about both of those things within there. Is that what?
I got two different ones. One says is entitled motion title, motion to contest tax refund offset and request for review. And the next
Okay.
one at the
That's the
top
one.
says motion regarding support.
I have the first one that you mentioned. I don't know. He was sending things to my lawyer who's no longer, I'm not using them, so I don't know.
That was my second question. Is Ms. Slate representing you in this matter?
No, they were she said they were after 21 days after the last hearing, they were no longer my attorney on file. So
Okay. Well, did you send all that stuff, Mr. Reemer, to Ms. Slate instead of Ms. Reemer?
I sent it to her attorneys because that's what the folks at Legal Assistance had on file and told me to send it to her attorneys.
Yeah, you can't, once a
they
case
did.
is, hang on a
Sorry.
second. I got this, Ms. Reemer, if that's okay with you.
Yeah, sorry.
You can't do it that way, Mr. Reemer. You have to, what I always tell people is, because it's a logical conclusion, but attorneys don't represent clients forever. And generally speaking, usually it's 3 weeks after the case in which they were retained is over, then they are no longer the attorneys. And generally speaking, when I see these situations, is probably the best advice that I can always give to people representing themselves is to contact the attorney's office directly and ask them if they're still representing her, and they probably could have gotten you that answer pretty quick and taken care of it that way, because I can't proceed when the motion is not served properly. So you're going to have to adjourn these and serve her directly 9 days by first class mail, 7 days by process server.
They were both sent at the same time, and I just did what Legal Assistance, told me to do. I can't afford a lawyer. I'm so
well. Let me ask you this. Let me tell you this. I always have a rule of thumb, Mr. Reemer. You cannot rely on advice you don't pay for. And I know you didn't pay anybody at the Legal Assistance Center to give you advice, because they're not lawyers there, and they probably have about 50 signs that tell you that. So I don't fault you for doing it this way. I'm just telling you that I can't proceed today because of that, and that you need to renotice this for another motion day and send it to her directly at her last known address. And it has to be served at least 9 days if by mail, and you don't have to get crazy with it. It doesn't have to be certified or anything like that. First class mail is fine. Or if you're going to have a process server serve her, it has to be served 7 days before.
So just to make sure I understand, so I need to file a new motion, each one of those?
No.
Okay.
You need to file a renotice of motion. And what that does is that saves you from having to pay another filing fee. So whatever, if they charged you any filing fee for filing these motions,
They did.
You don't have to pay that again. That's why. So you would just renotice the motion. It's the same motions. I got them. And send them first class mail or process server to Susan directly. Okay. And the Legal Assistance Center has the renotice forms. So what I would do is I would renotice it so you don't have to pay another fee, send her copies of what you have filed already, and then she's got everything, I have everything, you have everything, and then we can get busy. That's what I would do.
Okay. I don't quite understand, just because in her responses, they're filed by attorney for defendant Allison, or attorney for defendant Allison Slate. It's listed right here.
Yeah, I can't make sense of any of that for you. All I can tell you is what the law lets me do. See, the problem is if I act on your motions today, anything I do would be automatically reversible because notice hasn't been provided. And I don't want to, because if that happens, then you would have to pay another fee to come back. And I don't want that. So that's the
Okay.
only reason I'm doing that.
Just to clarify though, because
I can't keep clarifying it for you.
Okay, I'm just super confused why the
I
response.
can't help you with that, Mr. Reemer. That's why the law is, it takes 7 years to go and graduate from law school. 3 years of law school, 4 years of college. It's confusing stuff. But there are people that can help you. However, there's a lot of attorneys now that handle what are called limited scope representation. They can prepare things for you and help you with service and all that, at not nearly the cost it is to represent you. So there's a lot of suggestions I have. The only thing I'm trying to tell you, and I know it's frustrating.
Very frustrating.
But I'm trying the courts are built for fairness, not for speed.
That's all I'm trying to do, is get something that's fair.
Yeah, and that's what it's built for. And in order for it to be fair, everybody's got to know what everybody else's thought process is. So please do that. And I will see you back here when service is proper. Okay? You can sign off, both of you. Thank you very much.
Thank you, Your Honor.
Sharmika and Naeves?
Yes.
All right, Ms. Naeves, good morning to you.
Good morning.
So I have read your motion, Mr. Jones. You got a copy of that, did you not, Ms. Naeves?
Yes, I did.
Okay. Let me tell you what I know, and then I'll hear from both of you. What I know is that the last custody, parenting time, and child support order was dated not that long ago, August 28th of 2025. And the parties were granted joint legal and physical custody of their child, who I'll use the initials KAJ, relative to the dependency exemptions. What do you want to tell me on that? Mr. Jones, it's your motion.
Oh, I just the judge, she granted me joint custody. I just feel like everything should be fair. I have KJ from Friday to Friday. We do a week on, week off. When she's with me, I provide clothes, food, transportation to school. I'll take her to doctor appointments. Like, everything's pretty fair, except for that I'm the filing of the taxes. She just turned 8. I've never ever filed for her, and I've been in her life since birth. I submitted my insurance, that I pay for her every week. So it's like I don't think what I'm asking for is unfair. FOC granted me odd years as far as like Thanksgiving and Christmas and stuff like that. So I was asking that if it is granted, that I'll be granted odd years for the for the tax deductions. That way everything is together, nothing is confused as far as like who turn it is to file and stuff like that.
Ms. Naeves, your thoughts, please.
I don't have no problem with it, but we did have a talk previous before all this happened. I did give a call out. I did reach out to him and let him know that I was going through financial situations, and I was asking him, is there some way we can drop the child support? So we did agreed on that, and we were supposed to come up there and file for that, but turned around and I'm here. So I did receive the paper, I did read it, and I don't have a problem with it. I did let him know before this even happened that I didn't have a problem of going back and forth with filing our child for taxes. So that never been an issue with me, and it's still not an issue with me.
Okay, so so he can claim KAJ in odd years, and you can claim KAJ in even years.
That's correct.
Okay. Then, Mr. Jones, you need to prepare an order. And let me tell you how you do that. What you do is you go to the 5th floor Legal Assistance Center. Tell them that you need to prepare an order, that they will give you a piece of paper that will say order on it and have a bunch of blank lines. And then you put what the agreement is, that you will claim KAJ in odd tax years for all state, federal, local purposes, and Ms. Naeves will claim KAJ in all even years. Now, just remember something, that when you file your taxes, you're filing it in an even year, but it's for an odd year's income. You understand that, right?
Yeah, yes, sir.
Okay.
Yeah.
You understand? I just want to, because some people get a little confused about
Yeah,
that.
but yeah, basically I would file this year because it would be, yeah, I know what you mean.
All right. So prep that order, get it to me, and get a copy to Ms. Naeves, and I will sign it. How's that?
So do I gotta wait for your judgment to come or do it now?
Well, you gotta, no, you have to, you're the one preparing the order. So you have to prepare that order now and get it to me and get it to Ms. Naeves. And then once I sign that, you will be good to go.
All right.
Okay.
Yeah.
And a lot of times there's forms the IRS might have you have to fill out, and your order should also say that parties shall cooperate and sign whatever orders that are necessary to carry this out. Okay. It's a good way to do things, just in case the IRS needs another form by the other party every other year or whatever. Okay.
All right.
You're all
I
set.
have a question, Your Honor. Do we both got to go down there and get the paper, or he can just go down there and fill out himself, or do we both got to sign the paper?
Well, you both have to sign it, but he can go down there himself and fill it out. He
Okay.
can just send it to you or drop it off at your house. And then once you
Okay.
both sign it, it's got to get to me, and then I have to sign it. And then we're good to roll. Okay.
Okay.
All right. Thank you both very much. Wish you both the best going forward, and you can sign off. Thank you.
Thank you.
All right. Thank you.
And is Amanda Riley or anybody on Miss Riley's behalf present in the virtual courtroom? I don't see her in there. So let me, if I could, Mr. Singleton, ask you a couple of questions.
Go ahead.
So it says on your motion that, and you signed it and dated it for October 23rd of 2025.
No,
Says
no.
hang on, let me get the question out first, okay?
Yeah.
Because you're muting out my microphone
Gotcha.
when both of us talk at the same time, okay? So it says on a certificate of mailing, it says, I certify that on this date, and you signed it October 23 of 2025, that I served a copy of this motion and notice of motion or notice of hearing on the parties or their attorneys by first-class mail addressed to the last known address as defined by court rule. So my question is, did you in fact do that?
Yes.
Okay. And it didn't come back to you in the mail or anything like that?
No, it did not.
Okay, so she should have been aware of this, apparently is not here. Is that your understanding?
Correct.
Okay, so I read your motion. Let me see if I can help you out a little bit. So your son, he's 18 now. Is it Kaveri?
My daughter,
Or daughter, is it Kaveri?
Kevery.
Kevry. Okay. So your daughter Kevry is 18 right now. Is that correct?
Yes, and graduated from high school.
Okay. Well, that was my next question. And she graduated from high school as well, correct?
Correct.
Okay. And I did confirm with the staff attorney from the front of the court that the case is still charging. The emancipation date in the most recent uniform child support order was dated 5/31/26. So what they need from you and me is they need a new order to stop that. So here's my question to you. What month did she graduate?
She graduated June 2025.
Okay. So what the court rule or the child support guidelines say that effective July 1, your child support for this child will end. Okay. So they need an order at the front of the court before they can do anything. And you need to prepare that. And what you would do is you go to the 5th floor Legal Assistance Center. They will show you how to prepare an order terminating your child support. If for this child, I don't know if you have support obligations for any other children, but it's got to say specifically for this child and put her date of birth on there. Effective July 1, 2025. So you do that, and then they will show you how to get that to me, and then I will sign it, and then that should solve your problem.
So I went to the legal aid office and filled this out with them. And
yeah, I got it right in front of me.
Yes. So this is what they should have had written in the first place. So I have to spend another
No. This is not what they should have done in the first place. What they're doing is they're filing, they assisted you at no cost. It should have been.
No, it was sick. I had to pay for it.
You had to pay a motion fee probably, right?
Okay.
Okay. So what they did is help you prepare a motion. Now they got to help you prepare an order because you won your motion. Most people that win their motions are a little bit more happier than you are.
Okay. No,
Okay.
I didn't understand. I didn't understand it, Your Honor.
Okay. But you have to be very particular in this order. It's got to have your daughter's name and her date of birth. And it's also got to stop the child support effective July 1 of 2025. Because then they'll take care of any arrears you may owe from July, August, September, October. Okay.
Okay.
Head down to the 5th floor. The sooner I get that, and then you got to send her a copy, Miss Riley, even though she's not here. But I'll sign that, and that should take care of business for you.
Okay. All right.
All
Well,
set
thank you, sir. So you said 5th floor with the court just at the legal aid office, and
well, it's not. See, don't confuse it. It's not the legal aid office. It's the legal assistance center. Legal aid is a whole different ball game.
Okay.
They're not on the 5th floor, but legal assistance center. They'll help you out.
Gotcha. Okay.
Have a great weekend.
Thank you.
You bet.